For 163 years, if you committed a crime in India, you were basically judged by a rule book written by British colonizers.
Right, which was entirely designed to control their subjects.
Yeah, and I mean, just think of the gravity of that for a second. Every single arrest, every trial, every conviction in modern democratic India was ultimately rooted in the Indian Penal Code of 1860.
Exactly, the IPC. It was drafted by Lord Macaulay to, impose Victorian morality and protect the state apparatus of the British Raj.
Which is wild when you really think about it.
Yeah.
But today, for this deep dive, we are looking at what happens when a country finally rips up that colonial-era code.
And replaces it with a completely new philosophical framework, which is the Bharatiya Nyaya Sanhita of 2023, or the BNS for short.
And okay, let's unpack this because the magnitude of this transition is just staggering.
Oh, it's massive. We are not talking about a simple copy edit here. It's not like they just struck down a few archaic laws and handed out some new section numbers.
Wait, it's way deeper than that.
Yeah, the BNS represents a very deliberate structural departure from a system designed for basically law and order over a subjugated population.
Right.
It moves everything toward a modern, victim-centric, rights-based framework. The fundamental lens of the justice system has completely shifted.
Shifted away from just punishing disobedience. Right?
Exactly. It's now about prioritizing human dignity, bodily autonomy, and individual rights, particularly for the most vulnerable segments of society.
Which brings us to the mission of this deep dive. We are going to map out exactly how that philosophical shift actually plays out in the mechanics of the law.
Because the mechanics are where it gets real.
Yeah, and to do that, we have to start at the bedrock. First, we'll establish the foundational rules, what actually constitutes a crime and what doesn't.
The general explanations and exceptions.
Right, and then we'll dissect how a mere thought actually turns into a criminal act, which covers abetment, conspiracy, and attempt.
And finally, we will spend the bulk of our time on Chapter 5.
Yes, the beating heart of the BNS, which completely overhauls the laws protecting women and children.
It's a total paradigm shift.
So before anyone steps into a courtroom or faces a judge, the law has to actually define the reality it operates in.
Right, the definitions. The words we use in these statutes literally dictate who gets protected and who falls through the cracks.
And the source material highlights a massive linguistic change right out of the gate in the BNS. It changes how the law views young people.
Yes, the removal of the word minor.
Exactly. The word minor has been entirely scrubbed from the code. It's replaced uniformly with the word child under Section 2, subsection 3.
And, at first glance, swapping minor for child might just look like a basic modernization of vocabulary. Like, okay, they just updated the dictionary.
Right, just a stylistic choice.
But legally, it fundamentally changes who gets protected. Under the old IPC, a huge number of provisions dealing with really horrific crimes, trafficking, kidnapping, sexual exploitation, they relied on the specific phrase, minor girl.
Minor girl. Wow, so that language inherently gendered the protection.
Exactly. It created a massive blind spot in the justice system. It basically ignored the tragic reality that boys and transgender youths are also frequent victims of those exact same crimes.
So by defining child uniformly as any person below the age of 18, and just using that term across the board, the BNS forces the system to cast a protective net over everyone in that age bracket.
It takes the blinders off the law.
Because if a 16-year-old boy is trafficked into forced labor now, the perpetrators can't try to find a loophole, right? They can't argue that the specific statute only explicitly mentioned minor girls.
No, they can't. The law now recognizes the vulnerability of the age itself, rather than attaching that vulnerability exclusively to a specific gender. It creates the standardized gender-neutral shield.
Which is such a necessary update. And we see another really profound example of this linguistic recalibration in Section 3, subsection 3, which deals with the legal recognition of holding property.
Ah, yes, the spouse update.
Right. The original text presumed that only a wife would hold property on behalf of her husband. But the BNS replaces wife with spouse.
Which is huge because that actively dismantles the old patriarchal assumption that the man is automatically the sole economic driver or the sole property owner in a marriage.
It totally acknowledges the modern economic reality.
Yeah.
A marriage is a financial partnership, and either spouse can hold property on behalf of the other.
It's really fascinating how updating just a single noun forces the entire legal apparatus to treat a marriage as an entity of equals.
Absolutely. But establishing these definitions also sets up the boundaries of the law. Once we know who is who, we have to figure out when a crime is actually a crime.
Because normally you need the act and the intent, right? The actus reus and the mens rea?
Yeah, but the general exceptions chapter of the BNS outlines these incredibly complex scenarios where someone commits a violent or destructive act, but the law legally forgives them.
Right, spanning sections 14 to 44. The law recognizes that human reality is just incredibly messy.
Messy is a good word for it.
Sometimes, inflicting harm is literally the only way to prevent a much greater catastrophe. The law has to account for emergencies, medical necessities, and cognitive incapacities.
Because if the system rigidly punished every single action that resulted in injury without looking at the context or the intent behind it, society would just paralyze itself.
Exactly. No one would ever help anyone in an emergency.
Right, which brings up this very intense, almost Dickensian illustration from the source text to explain Section 30. This deals with acts done in good faith for the benefit of a person without their consent.
The surgeon example.
Yes. So imagine a surgeon who finds an unconscious person named Z who has just been thrown from a horse. The surgeon examines Z and realizes there is immense pressure on the brain.
A life or death situation.
Completely. So the surgeon decides Z requires to be trepanned, which literally means drilling a hole into the skull to relieve the pressure.
A very old, very serious procedure.
Right. And he performs this brutal surgery on the side of the road before Z ever wakes up to give consent. Technically, drilling into a stranger's head is a severe, violent assault.
It's a textbook case of grievous bodily harm. However, under Section 30, the surgeon has committed no offense.
Even though he drilled into someone's skull.
Even though he did that. Because the law evaluates the totality of the circumstances. The surgeon didn't intend to cause Z's death. The intent was the exact opposite.
Right, to save his life.
And furthermore, it was an emergency where it was impossible for Z to signify consent. And the surgeon acted in good faith strictly for Z's benefit.
There is another wild illustration from the text about a tiger.
Oh, the tiger one is classic.
So a victim is being dragged off into the jungle by a tiger. A bystander fires a gun at the tiger, knowing the shot might miss the animal and hit the victim, but acting entirely in good faith to save their life.
Right.
The bullet misses the tiger, hits the victim, and causes a mortal wound. The law shields the shooter.
Because of the doctrine of necessity. We want people to intervene in terrifying emergencies.
Okay, I understand that. But let me apply a modern analogy to test the limits of this good faith protection.
Sure, let's hear it.
Let's say I see someone collapse on the sidewalk. I have zero medical training, but I decide to perform CPR. And in my panic, I pump their chest so aggressively that I shatter 3 of their ribs and puncture a lung.
Ouch. Okay.
Or I've caused severe trauma. Can I just stand in front of a judge, shrug, and say, hey, I was acting in good faith, my heart was in the right place, and expect complete immunity?
Well, no, you cannot rely purely on your subjective internal feeling of being a hero.
Yeah.
The law anticipates that exact defense.
So good faith isn't just about meaning well.
Not at all. The BNS carries over a very strict legal definition of good faith. An act is not legally considered to be done in good faith unless it is done with due care and attention.
Due care and attention. Okay.
The courts will look objectively at your actions. Was it reasonable to believe CPR was required? Did you attempt it to the best of your ability given your lack of training?
So they do make allowances for me not being a doctor.
The law makes wide allowances for panic and lack of professional expertise in a crisis. But if you decided the best way to revive the person was to jump up and down on their chest with both feet,
Which would be crazy.
right, that completely lacks due care and attention. Your subjective intent to help wouldn't save you from liability because your objective actions were recklessly disproportionate.
That makes perfect sense. It balances the need to encourage good Samaritans with the need to protect victims from sheer recklessness.
Exactly.
Now, how does the BNS handle situations where the concept of intent is completely broken? Like, I'm looking at Section 14, which covers legal insanity.
Section 14. This retains the foundational legal standard known as the McNaughton Rule.
The McNaughton Rule. What does that stipulate?
It stipulates that nothing is an offense if it is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that what they are doing is either wrong or contrary to law.
So this isn't just about having a diagnosed mental illness.
No, not at all.
You could be severely mentally ill, but if you still understand that pulling a trigger is legally and morally wrong, you don't get the protection of Section 14.
Precisely. It specifically tests your cognitive capacity at the exact moment the act occurs. It is a very strict cognitive test.
So if I have an irresistible impulse, but I know it's a crime.
It does not cover irresistible impulses. If you still retain the knowledge that the act is wrong, you are liable. The law demands that the unsoundness of mind entirely obliterates your understanding of the physical nature of what you were doing.
Wow, that is a high bar.
Very high.
So we've talked about when lack of consent is forgiven, but Section 29 introduces a hard limit on what can actually be consented to. You can't just consent to anything and magically make it legal.
Right, you can't contract your way out of certain crimes.
The source explicitly mentions causing a miscarriage. Even if an adult woman fully consents to a procedure that causes a miscarriage, it remains an offense independently of the harm caused.
Unless, of course, that procedure was done in good faith for the purpose of saving her life.
Right, the life-saving exception.
Yeah.
But otherwise, consent doesn't matter.
Exactly. The law draws a line where the state has a vested interest in the act itself, regardless of the agreement between the parties involved.
Okay, so Section 29 clarifies that consent does not excuse acts that the law defines as offenses independently of any harm they might cause.
Because this ensures that vulnerable individuals cannot be pressured or coerced into consenting to acts that society has deemed fundamentally unlawful or deeply harmful to public policy.
Right, and understanding these boundaries, what intent looks like, what good faith means, what consent covers it, it's critical because it sets the stage for how a crime actually builds up.
Yes.
The BNS doesn't just wait for a victim to be harmed. It heavily polices the anatomy of a crime as it develops. Which brings us to Sections 45 through 62.
Tackling abetment, conspiracy, and attempt.
Right. This is all about how dark, abstract thoughts manifest into punishable reality.
Well, criminal jurisprudence generally recognizes 4 distinct stages of a crime. First is intention, the thought itself.
But we don't punish pure thought crimes.
Right. Exactly. Thinking about robbing a bank is not illegal. The second stage is preparation. And generally, mere preparation is not punishable because the person might still change their mind.
So buying a ski mask doesn't make me a bank robber.
Right. The law steps in at the third stage, attempt. This is where the person takes a direct, overt step toward committing the crime, passing the point of no return.
And the final stage
is, of course, commission, where the crime is successfully completed.
Okay, let's dissect attempt, which is governed by Section 62 of the BNS. The text uses an incredibly elegant analogy about a pickpocket.
It's a great example to explain a tricky concept.
Right, so a person thrusts their hand into someone's pocket, intending to steal whatever is inside. But it turns out the pocket is completely empty.
So the theft is impossible.
Exactly. The act of theft is physically impossible to complete in that specific moment. Yet, under Section 62, this is still heavily punishable as an attempt. But why? They didn't actually steal anything.
Because the mens rea of the guilty mind was fully formed. And the actus reus, the guilty act, was initiated and carried out as far as the perpetrator could possibly take it.
Ah, I see.
The failure of the crime wasn't due to the perpetrator changing their mind or showing remorse. It failed due to an external circumstance entirely outside their control.
The pocket just happened to be empty.
Exactly.
Yeah.
The law punishes the dangerousness of the individual's conduct. Under the BNS, if you attempt an offense punishable by imprisonment, and no specific provision exists for the attempt, you can be punished with up to half of the maximum term provided for the completed offense.
Up to half. That's substantial.
It is.
But that concept of punishing the buildup becomes exponentially more complicated when you involve multiple people. Sections on common intention and criminal conspiracy try to unravel who is responsible for what when a group commits a crime.
Group dynamics are always legally complex.
Right. So let's look at Section 40, dealing with common intention.
So, common intention requires a shared state of mind among multiple people and a prearranged plan. If a criminal act is done by several persons in furtherance of the common intention of all, each of those persons is liable for that act exactly as if they had done it alone.
Okay, let me make sure I understand the mechanics of this in a real scenario.
Sure.
Let's say person A, person B, and person C all agree to ambush and beat person D. They all show up with weapons. During the ambush, person A hits D in the head, and D dies from that specific blow.
Okay, a fatal strike by A.
Right. Now, person B and person C only hit D in the legs. Are B and C equally guilty of culpable homicide, even though their specific strikes were not fatal?
Yes, absolutely.
Just for hitting the legs.
Yes, and this is a vital legal mechanism. Without the doctrine of common intention, criminal syndicates or gangs would constantly exploit technical loopholes.
How so?
Well, if 10 people attack someone, it is often medically impossible to prove which specific blow caused the death. Without this provision, all 10 could argue they only meant to cause simple hurt, and the prosecution couldn't secure a murder conviction against anyone.
Oh, wow. I never thought about that.
Right. Section 40 ensures that if you share the lethal intention and actively participate in the plan, you bear the full weight of the ultimate consequence, regardless of whose physical hand delivered the final strike.
It prevents the diffusion of responsibility.
Exactly.
The BNS also addresses criminal conspiracy under Section 61. It consolidates scattered provisions from the old IPC, but it adds a very specific phrase, common object.
Yes, that addition is crucial.
Section 61, subsection 1, now applies to a conspiracy to commit an offense with a common object. Why add those two words? Does it actually change anything?
Oh, it changes a lot. Adding common object raises the threshold to prevent the misuse of conspiracy laws. Conspiracy is a unique area of law because it punishes the mere agreement to commit an illegal act, even before an attempt is made.
Right, punishing the planning stage.
Because the threshold for intervention is so early, it can easily be abused by law enforcement to round up individuals who merely discuss something illicit without any real structure or unified goal.
So just talk.
Exactly. Requiring a common object means the prosecution must prove a cohesive, shared purpose among the conspirators. It ensures the law targets actual organized criminal plotting rather than loose, hypothetical talk.
That flows directly into abetment, covered from Section 45 to 60. Abetment essentially breaks down into instigating a crime, conspiring to commit it, or intentionally aiding it.
Yes.
The source provides a really chilling illustration about poison to explain this.
The poison plot.
Right. A and B scheme together to poison Z. They need the poison, so they bring in C. C knows exactly what A and B are planning.
Right.
And C procures the poison and hands it to A. A eventually administers the poison, and Z dies.
A classic abetment scenario.
But the kicker here is that C never explicitly conspired directly with A on the timeline or the method of the murder. C just got the poison.
But C is still fully liable for the murder of Z.
Even without planning the actual murder.
Yes. The law of abetment by intentional aiding does not require you to be a mastermind or to know every intimate detail of the plot. By knowingly supplying the lethal means with full awareness of the intended outcome, C intentionally facilitated the crime.
So it severs the defense of, hey, I just bought the supplies, I didn't pour the drink.
Exactly. If you intentionally oil the gears of a murder machine, you are guilty of the murder.
And exploring how the law treats these group dynamics and shared intentions brings us to the most monumental architectural change in the BNS.
Yes, the big one.
The lawmakers didn't just update definitions or tweak conspiracy thresholds, they completely restructured the hierarchy of what the justice system values most.
They took provisions that were scattered haphazardly throughout the old IPC and pulled them right to the front.
Which brings us to Chapter V.
Chapter 5 is the beating heart of the Bharatiya Nyaya Sanhita. Under the colonial IPC, offenses against the human body were buried deep in Chapter 16. Offenses related to marriage were pushed all the way back to Chapter WEX.
So what did that structure communicate?
It subtly communicated that crimes against the state or crimes against property were of primary concern. The state came first.
But the BNS radically shifts this paradigm.
Completely. It takes all the provisions dealing with the protection of women and children and elevates them to Chapter 5, placing them ahead of almost every other major category of crime.
It is a massive signaling mechanism to the judiciary and law enforcement.
It really is.
It aligns the penal code with progressive modern Supreme Court judgments like Joseph Schein and independent thought, basically stating unequivocally that the bodily autonomy, dignity, and safety of women and children are the absolute highest priorities of the modern Indian legal framework.
And this structural prioritization is backed by intense substantive changes to the actual laws, particularly regarding sexual offenses in sections 63 through 73.
Okay, let's get into those changes, because the redefinition of consent in rape cases is one of the most vital transformations. Under the old colonial framework, the law relied heavily on the phrase "against her will."
Yes, a very problematic phrase.
That phrase is completely gone from the BNS. Instead, the standard for consent is now explicitly defined as consent given in a conscious, voluntary, and informed state.
And if we connect this to the bigger picture, removing against her will eliminates a deeply toxic ambiguity that defense attorneys weaponized for over a century.
How did they weaponize it?
Well, against her will implied that the victim had to actively physically fight back to prove she didn't want it. It put the victim's resistance on trial.
So it wasn't about what the attacker did, it was about how hard the victim fought.
Exactly. It forced courts to ask, did she scream loud enough? Did she struggle hard enough? If a victim froze out of absolute terror or was intimidated into submission without physical force, the defense would argue it wasn't strictly against her will.
So, by shifting to conscious, voluntary, and informed, the entire burden of the courtroom inquiry changes. The question is no longer, did she fight back?
No.
The question is now, does she freely and consciously agree?
Exactly. It fundamentally recognizes bodily autonomy. If a person is intoxicated, manipulated, or operating under a severe power imbalance, they cannot give informed or voluntary consent.
Right.
It modernizes the courtroom to reflect the psychological realities of trauma and coercion. It completely removes that archaic requirement of violent resistance.
And this nuanced understanding of coercion is crystallized in a brand new provision, Section 69. This specifically targets sexual intercourse through deceitful means.
A very necessary addition.
The BNS now makes it explicitly punishable to obtain sexual consent by making a false promise of marriage, a false promise of employment or promotion, or by suppressing one's true identity.
Section 69 addresses an incredibly pervasive modern reality where predation isn't about jumping out of an alleyway, it's about systematic manipulation.
Right, using power dynamics.
Previously, cases involving false promises of marriage were shoehorned into general rape provisions, and that led to wildly inconsistent judgments across different courts.
Because some judges didn't see it as rape.
Right. Some judges would convict, viewing it as a vitiation of consent, while others would just dismiss it as a mere breach of a social contract, like a bad breakup.
Wow.
But by creating a dedicated section, the legislature has provided absolute clarity. If you intentionally manufacture a false reality, like promising a marriage you have no intention of following through on, or dangling a job promotion to extract sexual consent, that consent is legally void.
And it's treated as a serious crime.
Yes, punishable by up to 10 years in prison.
And when we look at the aggravated punishments under Section 70, the BNS introduces severe enhancements, particularly regarding gang rape.
The penalties are incredibly strict now.
Previously, the age threshold for the most extreme punishments in gang rape cases was 16. The BNS raises that age. Now, the gang rape of any woman under 18 years of age carries a mandatory sentence.
And not just any sentence.
Right, either life imprisonment, which is explicitly defined as the remainder of that person's natural life, or the death penalty.
It is the ultimate manifestation of the state's protective duty. Raising the threshold to 18 perfectly aligns the punishment matrix with the new universal definition of a child we discussed earlier.
Right, uniform protection up to 18.
It removes any leniency for group predation against minors, utilizing the absolute maximum force of the state's punitive power.
Now, the BNS recognizes that violence against women is not solely defined by physical penetration. The trauma inflicted can be spatial, psychological, and increasingly digital.
Which brings us to assault and criminal force.
Right. Sections 74 through 79 meticulously define assault and criminal force, explicitly tailoring these concepts to protect the dignity of women. Let's break down the mechanics here. What is the actual legal distinction between assault and criminal force in this context?
It is a critical distinction, and it's based on the timeline of violence. Assault, in the legal sense, is the anticipation of violence. Yeah. If someone makes a gesture or preparation that causes a person to reasonably apprehend that they're about to be subjected to unconsented force, that is assault. It is the raising of a fist.
Okay, so you don't even have to make contact for it to be assault.
Exactly. Criminal force, on the other hand, is the actual execution. The unconsented use of physical force to cause injury, fear, or annoyance.
Got it.
And the BNS takes these general principles and applies them with extreme prejudice when the intent is to outrage the modesty of a woman.
And we see a major progressive lead in Sections 76 and 77, which deal with the horrific crimes of disrobing a woman or voyeurism.
A very subtle but important language shift here.
Right, the old IPC used the phrasing, any man who commits these acts. The BNS has changed that language to whoever.
This is a profound acknowledgement of complex criminal realities. By shifting from any man to whoever, the BNS makes the perpetrators of these specific crimes gender neutral.
Wait, really? So women can be prosecuted under this?
Yes. It recognizes that women can, and sometimes do, participate in the humiliation or assault of other women, often acting in concert with men or enforcing patriarchal norms.
Oh, wow.
Furthermore, it means transgender individuals who commit these acts can be prosecuted under these specific, severe provisions. The law is no longer constrained by the gender of the attacker. It is focused entirely on the nature of the violation against the victim.
That's a huge shift. And that same modernization applies to Section 78, which covers stalking. When people hear stalking, they often picture someone physically following a person down a dark street or loitering outside their house.
Right, the physical shadowing.
And while that physical proximity is certainly covered, the BNS explicitly drags the law into the digital age. Stalking is now defined to include monitoring the use of the internet, email, or any other form of electronic communication.
Here's where it gets really interesting, because we live in an era where an abuser can inflict relentless terror without ever leaving their living room.
Yeah, digital stalking is terrifying.
A stalker can track a victim's movements via GPS, monitor their social media interactions, or flood their digital life with threats. Section 78 recognizes that digital space is an extension of personal space.
Which it absolutely is nowadays.
The psychological devastation of having your private electronic life monitored and controlled is immense, and the punishment structure reflects the severity, up to 3 years for a first conviction and up to 5 years for a subsequent conviction.
It's important to note that while the perpetrator under the stalking provision is currently defined broadly, the primary focus in this chapter remains the protection of women.
True.
However, as digital landscapes evolve and the nature of cyber harassment changes, the judiciary is increasingly looking at these provisions through a wider lens. We are seeing a legal framework that is finally catching up to the internet.
Exactly. The law cannot remain static when the tools of abuse innovate so rapidly.
Moving from the public and digital spheres, the BNS turns its focus to the most private sphere imaginable, the home.
Marriage and domestic life.
Right. Sections 80 through 87 examine how the law protects individuals within the institution of marriage. And this is where we see the final, decisive dismantling of Victorian patriarchy. The source notes the absolute deletion of the language from the old Section 498 of the IPC, which criminalized taking away or enticing a married woman.
The wording of that old law was astonishing.
It phrased it as taking the woman from that man or from any person having the care of her on behalf of that man.
That colonial phrasing literally treated a married woman as chattel, as the legal property of her husband.
Property. Just unbelievable.
The crime wasn't conceptualized as a violation of the woman's autonomy. It was conceptualized as a theft of the husband's property.
Wow.
The deletion of this language, along with the complete removal of the crime of adultery from the penal code, aligns the BNS with the modern Constitution.
Right.
The Supreme Court made it clear, a husband is not the master of his wife. The state has no business using criminal law to enforce marital fidelity or to treat women as objects that can be stolen.
But the state absolutely has a role in intervening when that domestic space becomes violent. Sections 85 and 86 define and punish cruelty by a husband or his relatives.
And crucially, it's not just physical beatings.
Right. The source references the landmark G.V. Sidermish case, which established that cruelty encompasses deep psychological abuse as well.
The Sidermish case was instrumental in broadening the understanding of domestic trauma. The courts recognized that repeated verbal abuse, constant emotional degradation, or relentless harassment can inflict wounds just as profound as physical violence.
And the VNS actually codifies this understanding.
Yes. If the conduct is of such a nature that it is likely to drive the woman to commit suicide or cause grave injury to her mental or physical health, the state will prosecute it as a severe criminal offense.
This legal mechanism are incredibly stringent to ensure perpetrators cannot hide behind the veil of a tragic accident.
Dowry deaths are a horrific issue, and the law needs to be aggressive here.
So if a woman dies of burns or bodily injury, or it occurs otherwise than under normal circumstances within 7 years of her marriage.
Right, the 7-year window.
And it is shown that soon before her death, she was subjected to cruelty by her husband or his relatives in connection with any demand for dowry. The law automatically presumes it is a dowry death.
It creates a powerful legal presumption. In many cases, proving murder within the closed doors of a marital home is notoriously difficult. The perpetrators control the scene.
So this presumption changes the game.
By creating this specific provision, the law essentially shifts the burden. If a young bride dies unnaturally after facing dowry harassment, the system presumes culpability. It mandates severe punishments ranging from 7 years to life imprisonment. It is a targeted legal weapon designed to eradicate a specific culturally entrenched form of lethal greed.
The BNS also regulates the structure of marriage itself through bigamy laws in sections 82 to 84. It is an offense to marry again during the lifetime of a husband or wife.
Generally, yes.
But the text outlines specific exceptions. What if someone finds themselves in a situation where their spouse completely vanishes? Are they legally trapped in a ghost marriage forever, unable to move on without committing a crime?
No, the law provides logical release valves. You are not guilty of bigamy if your first marriage has been declared void by a court or if you have obtained a legal divorce.
Right, but what about the vanishing spouse?
Crucially, regarding a missing spouse, the BNS integrates with Section 108 of the Evidence Act. If a spouse has been continually absent and unheard of for 7 years by those who would naturally have heard from them, the law presumes they are dead.
The 7 years, okay.
You can legally remarry, provided you inform your new partner of the true state of facts regarding the previous marriage.
That addresses the civil reality of abandonment. But this raises an important question. How does this penal code interact with personal religious laws? Certain religious frameworks permit polygamy. Does the penal code override that?
This is an incredibly complex intersection of civil, religious, and criminal law. If a person's personal religious law legally permits multiple marriages, for example, specific conditions under Muslim personal law, then entering into a subsequent marriage does not automatically trigger the bigamy provision of the BNS.
Okay, so there is an accommodation for personal law.
However, the courts have been exceptionally clear on a vital caveat. You cannot cynically exploit religious conversion as a legal loophole.
What do you mean by that?
If a person governed by a monogamous personal law converts to a different religion merely for the purpose of taking a second wife without a genuine change of faith, the courts will view that conversion as fraudulent.
Oh, interesting. So fake conversions don't work.
Exactly. The second marriage will be considered invalid, and the individual can absolutely be prosecuted for bigamy under the penal code.
That strictly prevents the weaponization of religion to bypass criminal statutes. Now, we've moved from the protections of the public sphere into the home, and finally we arrive at the absolute most vulnerable subjects under the BNS, the unborn and children.
The ultimate societal protections.
Right. Sections 88 through 99 deal with this. We touched on this earlier regarding consent, but sections 88 to 92 detail the specific crimes regarding causing a miscarriage.
The baseline rule is that intentionally causing a miscarriage is a punishable offense, carrying up to 3 years imprisonment. Unless it is done in good faith for the sole purpose of saving the life of the woman. The law seeks to protect potential life, but prioritizes the life of the mother in a medical crisis.
The shocking detail that leaps out from the source material is the escalation of punishment in Section 89. If someone causes a miscarriage without the consent of the woman, the punishment explodes. It can be life imprisonment.
Because causing a miscarriage without a woman's consent is an extreme, profound violation of her bodily autonomy. It is an act of horrific violence against her person.
So it's treated on par with the most severe crimes.
Yes. The exponential increase in the potential sentence from 3 years to life reflects the shift from an offense against potential life to a devastating assault on the woman herself.
The law then extends comprehensive protection to children once they are born. Sections 93 and 94 address dark realities that society often wants to ignore. The exposure and abandonment of a child under 12 years by a parent or guardian, and the secret disposal of a dead body to conceal a birth.
Very grim sections, but entirely necessary.
But I want to focus deeply on a new addition, Section 95. This explicitly punishes hiring, employing, or engaging a child to commit an offense.
This is a crucial modernization. Criminal syndicates often exploit children to carry out illegal activities from drug running to theft.
Because kids face less suspicion.
Exactly. And under juvenile justice frameworks, children face lesser penalties. Section 95 criminalizes the adult architects of this exploitation. If you use a child as a tool to commit a crime, you face severe punishment.
And the explanation attached to Section 95 is vital. It explicitly states that this section covers using a child for sexual exploitation or pornography.
Yes, that clarity, it's so important.
It totally removes any ambiguity, ensuring that the adults orchestrating the production of child sexual abuse material or facilitating the abuse are hit with the full force of this specific criminal provision.
And this dovetails directly into the enhanced punishments for trafficking and prostitution under Sections 98 and 99. Here again, we see the impact of replacing minor with child, ensuring the protection applies universally up to age 18.
Right, closing that loophole.
The BNS sets stringent mandatory minimum sentences here. Buying or selling a child for purposes of prostitution or illicit intercourse is not treated lightly. It carries a mandatory minimum of 7 years, extending up to 14 years, accompanied by a fine.
Wow, up to 14 years.
The state is establishing an absolute zero-tolerance policy for the commercial exploitation of children.
When you step back and look at the sheer scope of this transition, it is breathtaking. We've journeyed through the foundational mechanisms of the Bharatiya Nyaya Sanhita.
It's a lot to take in.
It really is. We've seen how a change in vocabulary from minor to child, from wife to spouse, can fundamentally rewire the justice system to be more inclusive and gender-neutral.
Linguistic shifts that have real-world impact?
We've explored the intricate legal boundaries of medical emergencies, the strict cognitive tests for insanity, and the exact moments an attempt actually becomes a crime.
The anatomy of crime.
Right. We've broken down how the law traps conspirators and abettors, refusing to let the masterminds hide behind the physical actions of others. And, most importantly, we've dissected the heart of this new code, Chapter 5.
The most crucial part.
Witnessing the deliberate structural prioritization of the dignity, autonomy, and safety of women and children over colonial-era priorities.
Because the BNS is not merely a legal update, it is a profound philosophical statement about what modern India values. It actively dismantles archaic patriarchal assumptions, modernizes the understanding of consent, acknowledges the reality of digital violence, and tightens the net around organized exploitation.
As we wrap up this deep dive, I want to leave you, the listener, with a final thought to mull over. There's a fascinating duality embedded in this new system.
Oh, absolutely.
On one hand, the BNS introduces progressive, reformative concepts, like community service for petty crimes, recognizing that throwing people in prison for minor infractions often does more harm than good.
A very modern approach to low-level crime.
But simultaneously, as we saw with the gang rape of minors, it introduces the ultimate severity, the death penalty. It is becoming intensely more reformative for the small mistakes and infinitely more severe for violations of bodily autonomy.
It's a stark contrast.
It is. The question moving forward is, as our social and digital landscapes continue to evolve at lightning speed, will this new 2023 framework be flexible enough to adapt to the unseen crimes of 2050? Or will society eventually require another complete ground-up overhaul?
It's the eternal challenge of jurisprudence, right? Writing laws today that can somehow govern the realities of tomorrow.
Very true. Thank you for taking this deep dive into the legal architecture of the Bharatiya Nyaya Sanhita with us. Keep questioning the structures that govern our world, and we'll catch you on the next one.